All right, welcome everyone. My name is Sarah McAllister. I am Senior Associate Director here at the Tulane Office of Career and Professional Development in the Office of Alumni Relations. Welcome to our weekly series, Professional Development Series. Today I have both Jake and Aaron, who are going to talk about Immigration 101, all things in terms of the work that they do and how you can take this information and apply it into the work that you're doing, or if you're interested in this work. So I'm really excited for the topic today. Before I hand it off to them, two main housekeeping things. I will be on the back end today, so if you have any technical issues, please feel free to direct message me. Also, use the chat for any questions, and Jake and Aaron will address those either during or at the end. This is being recorded and will be uploaded to our YouTube channel, and I will drop that link in the chat in a minute. And then there was one other thing and it left my brain, so I will put it in the chat as soon as I remember it. But with that, I am going to hand it over to both Jake and Aaron to introduce themselves and then kick us off on today.
Thank you, Sarah. My name is Jake Minster. I am an associate at Fragaman. It's an immigration law firm. The only thing we do is handle immigration. I'm a 2018 law graduate, and I'm very excited to be here today. I'm joined by partner Aaron Blumberg. Unfortunately, he's not a Tulane graduate, but we'll let it slide this time, and I'll let him introduce himself.
Thanks, Jake. Yeah, unfortunately, I'm not a Tulane alum, but through working with Jake, I have grown to gain a sense of appreciation for the university. So I'm delighted to be here with you today. I'm a partner at Fragaman. As Jake mentioned, we are exclusively an immigration law firm. We're actually the largest and oldest immigration firm in the world. And we today are going to talk about US immigration, but our firm actually does immigration to every country in the world. And so what we do is represent a lot of multinational corporations that are transferring people from, the US to the UK, from the UK to Australia, from Australia to China. So anything immigration, that is really in our wheelhouse. And so I'm going to turn it back to Jake, and he's going to get started with some US immigration information.
Thanks, Aaron. So today's agenda, this is going to just be a high-level overview of the non-immigrant visa categories, and we'll kind of explain what that is throughout the presentation. So we're going to have a U.S. immigration overview, and then we're going to discuss common employment. Sorry, I'm hearing a little bit of background noise. Are people joining able to mute themselves?
Yes, and I'll make sure that.
Thank you, Sarah. Then we're going to discuss some of the common employment-based non-immigrant categories. So we'll talk about professionals, H-1Bs, L-1s, TNs, basically most of the categories that are used for work visas here in the United States. And then we'll field any questions that anyone has. So feel free to send questions into the chat throughout the entire presentation. We're happy to answer them. If we can't get to your question, our contact information is on this presentation, and then you can reach out to Sarah, and Aaron and I would be more than happy to answer your questions via email. All right, so let's get into it. So just to start things off, we're just going to go over some basic immigration overview. So really, what's a work visa and when's it needed? So U.S. visa sponsorship is it's about physical presence. Are you in the United States and are you working? At that point, yes, you would need a work visa depending on the type of work that you're doing. So I think a big misconception and a lot of things that happen is you'll see someone come here, they work abroad, say they work in the United Kingdom, they come to the U.S., they work for a company in the UK, they're paid out of the UK, but they're here on a working vacation and they think it's okay to work here because they are paid from the UK. That's not the instance. If you're in the US physically present here, you do need a work visa. It's important to remember too that immigration law is fluid. So every day we're seeing updates and changes from the different agencies that we work with. So check with us. That's why we're here. We're here to help. Just don't assume things, because it could end up being something that does hurt your case in the long run. We do see inconsistencies all the time in immigration. We might file two of the same applications at the same time. One could be approved in 2 months. The other one, it could take 8, 9, 10 months. That's just some of the issues that we do see. And then again, there are classification and categories that require a little bit more discretionary overview. The O1, which is an extraordinary ability visa, and then the P1 as well, which is for athletes. Immigration laws were mostly written in the 80s and 90s. They don't always account for our modern society or rapidly evolving technology. And this is really important in terms of kind of where we've gone from 2020, COVID-19 pandemic, into possible telecommuting, roving, these situations. So if you have any questions on that, please let us know. And then just a high level overview, immigrant versus non-immigrant. Today, we're talking about non-immigrants. So whenever you hear an immigrant, that's someone who has a permanent resident, which is also a green card holder. So immigrant, permanent resident, green card holder, all the same thing. We're talking about non-immigrants, so temporary workers that are coming here to work. An O1, P1, H2B, B1, everything we talk about in this presentation will be a non-immigrant. So some of the different agencies that we're involved with. So it's 3 different government agencies: Department of Homeland Security, Department of Labor, and the Department of State. And so we have United States Citizenship and Immigration Services. That's where we'll send applications. USCIS, everyone's heard of ICE. You have Customs and Border Protection. The Department of Labor is really setting wage levels for foreign nationals when we do want to sponsor certain types of applications. Not everyone requires certification. And the Department of State, you think about going abroad, getting your visa stamp. That's really what's going on there. The next slide will kind of discuss how these agencies work together. So how would you go about filing a petition, non-immigrant petition? So an employer would file a petition for non-immigrant classification. Most of these are going to require what's called a Form I-129 petition. But first, you might have to actually go to the Department of Labor and ask for a wage certification. So for instance, if you were doing an H-1B visa, you would need to have an LCA. You need that wage certification from the Department of Labor. Then you can move to the Department of Homeland Security, file the application with USCIS. Once that's approved, you can go to the Department of State to get the visa stamp. And that's kind of the way that all of these different agencies work together. Again, if you are approved, you get the visa stamp. Customs and Border Protection would admit you. You'd come into the country with your passport, and then you'd have an admitted until date. So Customs and Border Protection also creates a Form I-94 arrival departure record. We'll discuss on the next slide why that's important and why you should always go to the below website to obtain that record.
And I think, Jake, just to add, I think you can all see how this immigration system can get so confusing when you're dealing with different government agencies that still in 2022 don't always talk to each other. And so you're going to be dealing with different agencies throughout the process, throughout your time in the US, and things are not always the same. There's a lot of discrepancies. And so that, combined with the fact that these laws were written in the 80s, it makes it interesting for Jake and I, but I would say a little nerve-wracking and stressful for people that are going through this process.
Thanks, Aaron. So sponsorship and hiring. So unless you're a U.S. citizen or a permanent resident, again, green card holder, you're typically going to require an employer to sponsor you for a work visa. The exceptions could be TPS, which is temporary protected status. So if you think of Venezuelans who are here, Haitians who are here, this is temporary protected status. DACA recipients, people here who are claiming asylum, and there's some other categories as well. Throughout the presentation, we're going to refer to foreign nationals, and you're going to see it as FN as well throughout this webinar. So just so that you understand, a foreign national is an individual who is, 1, not a citizen of the US, and 2, not lawfully admitted for permanent residence. So they're not a green card holder, they're not a citizen. Sponsorship and hiring, it's applicable to both internal and external candidates. You might have an internal candidate who's already on a work visa and might need something else, or they might be on OPT, which is something that they just graduated with. They're allowed to work right after graduation, but they need sponsorship to then get on a work visa after that OPT. Just some reminders of acceptable screening questions, and these should always be asked as a pair. So it is acceptable to say, are you authorized to work in the United States? You know, if the employer response is, if no, please explain. You'd also want to ask, do you now or will you in the future need an employer to sponsor you for work authorization? And this isn't a straightforward question. I mean, this could be very confusing, and someone might have work authorization with another company, but that doesn't mean that they have work authorization with your company if they were to change employers. So it's always good to ask these questions. And if you have any questions about these or responses you do get from candidates, please reach out to us and we'd be happy to help. Okay, this is a really important slide, maintaining non-immigrant status. So we had talked about the I-94 earlier and getting a visa stamp and how you enter the country. So I think a lot of people, there's a misconception that the visa stamp is what controls everything in immigration, and that's not true. The visa stamp is really just the document that allows you to travel into the United States in the status that you are trying to come into the United States in. So you could come into the US on an H-1B visa stamp, and then once you have an I-94 record, which is what controls your ability to remain and work in the United States, your visa stamp could expire, but your I-94 might still be valid, and you could work according to that I-94 validity. The difference there is that if you were to then leave the country and then want to come back in, and your visa stamp was expired, you would need a new visa stamp in order to come into the country. Some of the consequences of overstaying the I-94 expiration date. The big one is that it can result in the cancellation of the visa, and then future visa appointments, they're going to have to be obtained in the home country. So wherever that foreign national is from. Sometimes we can send foreign nationals to what's called a third country if there is a backlog of visa appointments, and they might be able to apply for a visa in a country that's not their home. And that could be a quicker option sometimes. If you do overstay the I-94, that's no longer an option. The big one here is going to be on bars on return to the US after departure. So if you're more than 180 days over the I-94 expiration date, you could be subject to a 3-year bar. If you're over a year over the I-94 expiration date, you could be subject to a 10-year bar, and that's a significant amount of time. So it's very important that you track that I-94 expiration date. Another important reminder: if you are a foreign national and you change your address, you're always going to have to file a Form AR-11. It can be done on USCIS's website. You have to do it within 10 days of the move. And it's actually a very simple form to fill out. All right, so let's get into the alphabet soup of visas here. So again, I've highlighted the categories that we're going to go over, but as you can see, we have visa categories A through V. There are a lot of different visa types, and we're just going to go over a few of them today. All right, common employment-based non-immigrant categories. So we're going to start off with the H-1B specialty occupation professional visa. It's probably one that most people have heard of. It's one of the most popular non-immigrant visa categories. So it's open to professionals who are working in a specialty occupation. What does that mean? It means that you have a bachelor's degree or the equivalent of a bachelor's degree. Well, you might be asking yourself, can I hire someone if they don't have a bachelor's degree? What if they have an associate's degree? What if they have no education? Yeah, it could be possible. And there's something called the 3-for-1 rule. And basically what that means is that 3 years of experience is going to equate to 1 year of college. So if someone were to have no bachelor's degree, no associate's degree, and you wanted to hire them for a H-1B role, it could be possible to get them into the country and file the application. They have 12 years of experience. Again, that's something that we would need to look at, we would want to advise on. With the H-1B, we talked about the Department of Labor's role. You must obtain a labor condition application that's certified by the Department of Labor prior to filing the application. You submit this with the Department of Labor. It's a pretty simple form to submit, and within 7 to 10 business days, you do receive that certification. There's a 6-year max stay on the H-1B. Those are in 3-year increments, so you get 3 years and then 3 years. And then you can extend beyond 6 years under certain circumstances if you're pursuing a immigrant visa, permanent residence. So everyone's heard of the lottery, the immigration lottery. And really in immigration, there's 2 lotteries. There's one that is the H-1B cap lottery and one that's the diversity lottery. The diversity lottery, we're not going to discuss today. That's for an immigrant petition, a green card. The H-1B lottery is for a non-immigrant work visa. So every year there is an H-1B lottery. There's 65,000 annual cap on that lottery. 6,800 of these are set aside for Chilean and Singaporean nationals. And then there's a $20,000 additional slots allocated for holders of U.S. advanced degrees. So if you have a master's degree in the U.S., if you have a law degree, if you have a PhD, your chances of actually getting selected in the lottery are a little bit higher than those who don't. So cap filing season begins in April for each year. Really now it begins, I don't know, Aaron, what do you say, March, February? And we have to file the applications or file the registration in June. And then if selected, we can actually file the application. If approved, you wouldn't start until the beginning of the next fiscal year, which is October 1st. Dependent spouses. So if you're here on an H-1B and you have a spouse, they could come here on what's called an H-4. They are eligible to work in certain circumstances. Typically, if it's your first H-1B, you're coming straight from an F-1 to an H-1B, they're not going to have work authorization. And if you have questions on that, that's something that we can discuss. And then if the employer does lay off an H-1B worker, they do have to offer a reasonable cost of return transportation to the home country or the country of last residence. So just to give you a little bit of background on the registration of the lottery, we've included the past 5 to 6 years of the lottery and how many people have actually applied. As you can see, anywhere from 100 or around 200 to 300,000. And then in 2022, it just jumped to 484,000. That puts us at roughly 17% chance of getting selected. So it's not a great chance. So what's important is that if you're not selected in the H-1B lottery, there could be other options. And Aaron and I would be more than happy to help and kind of advise you on what those other options may be. Just because you're not selected doesn't mean that's the end of the road and you have to go back home or your employee has to go back home. There could be other options, and we'd be happy to take a look at their resume, CV, everything. And again, I talked about the lottery advantage, holding that U.S. advanced degree. And what's important to note there, at the time of the lottery, you don't have to have the degree, but the time we actually file the application, you do have to have that degree because we're going to have to include that degree with the application. So that's it on H's. Aaron, did you have anything to add?
No, I think to be honest with everyone, the H-1B for a lot of people is the only option. And if you don't get the H-1B, it is challenging. And some of the alternatives are not ideal. Like Jake's going to talk about the L1, which involves, if you have an employee that doesn't win the H-1B lottery, it may mean sending them to another country, working for one of your entities abroad and bringing you back. So while there are options, the H-1B is definitely number one. And it's a shame that the government hasn't really acted to increase the number, to really reflect what the economy is like. We saw 400,000 people that wanted an H-1B that couldn't get it, not because they weren't highly skilled, not because they weren't sponsored by a company, but just purely numbers, because 15 years ago, Congress said, this is the number we're going to cap it at, without taking a look at the job market, the economy, and things like that. But I'll let Jake talk about the other or backup options that we do have if you don't win that lottery.
Thanks, Aaron. So as Aaron said, this could be a backup option, but it's not going to be an immediate option. It would basically be send someone abroad to a qualifying organization for a year at least and bring them back. So the L1 is an intra-company transferee visa. It allows someone or an entity to sponsor and to transfer employees from overseas to a related company in the US. There's two types of L1s. There's called the L1A, that's for executives and managers. So managers, we're really looking at someone who is overseeing personnel, overseeing direct reports, or overseeing an essential function of the organization. And then the L1B is going to be the specialized knowledge worker. So when we talk about, okay, what is the related company? We're talking about qualifying relationship between the US sponsor and the overseas company. So that could be a parent subsidiary relationship, that could be an affiliate relationship, it could be a branch office, it could be a joint venture relationship. Again, there are different ways that we can show that there is some sort of qualifying relationship. And then the foreign national is going to have prior employment abroad, like we said, 1 year of overseas employment with the qualifying company and 3 years preceding the transfer to the US. And it's not just saying, oh, you can go over there and work for a year and then we'll bring you back. You'd have to go over there and work for a year in either a managerial position or a specialized knowledge position. And then you could come to the US in either of those positions. And then when we talk, I forgot to mention what specialized knowledge is. Really, specialized knowledge, what we're looking at there is do you have some sort of proprietary knowledge of the company, of the processes that the company engages in, of some of the data that they have, of some of the technology or software that company uses? And is that really well known throughout the entire company? Would it be easy to train someone in the United States on that, or is your knowledge so specialized that it would be, you know, important to get you to the U.S. to work and to help train other workers in the U.S.? So duration of stay, the L1A is good for 7 years, and the L1B is good for 5 years maximum. The initial visa is good for 3 years, or the initial stay is good for 3 years, and then you can renew in 2-year increments. So for the L1A, it'd be 3 years, 2 years, 2 years. The L1B would be 3 years and then 2 years. A little bit different than the H1B. Spouses can apply for work authorization right away, and then there is a new kind of update within the immigration world. So now there's something called incident to status. If an L2 spouse comes into the country and they're entered on the I-94 as an L2S, they automatically have work authorization, which is a really fantastic thing. Previously, we would have to submit an what's called an EAD application, employment authorization document, and those could take several months to approve. So that's it for the Ls. We're going to talk about some of the country-specific categories. And for this, we have TNs, E3s, and H1B ones. Really, what's going on here is that we have some sort of treaty or contract or something, you know, agreement with other countries, and you know, we have this work visa setup. So we can take in people from those countries, and we can send people there from those countries. So the TN is for Canadian and Mexican professionals. And just remember here, I know there's a lot of confusion. You have to be a citizen of these countries. You can't just be like a lawful permanent resident of Canada. You're going to have to be a citizen. You have to have a passport. So it was created under the North American Free Trade Agreement, NAFTA, but it's now known as the United States-Mexico-Canada Agreement, the USMCA. There are several occupations that are listed. So the foreign national has to be coming to work in an occupation listed on the USMCA. I think some of the big ones, engineer is a big one that's listed there, a mathematician as well. And then it is good for 3 years of the initial period and renewable in 3-year increments. And what's important to this is there's no maximum cap on it. You could renew as many times as you'd like, but if you start to renew, you know, say you're 10, 15 years into renewing here, there might be some questions as to, okay, what is your intent? Are you intending to stay here in the United States permanently? And something that I should have mentioned about the H1B and L1 is something called dual intent. So the H1B and the L1 visa categories are the only visa categories that allow you to have dual intent, which means that you can be in the US and have the intent to remain here and get a green card and stay permanently. Every other visa category we're going to talk about today, you do not have dual intent. And for those of you who are here as students, you probably know about this. You can't come here and then have the intent to remain here permanently, although a lot of people do. The E3 is for Australian professionals. There's 10,500 visas per year. You apply at a consulate. There's no USCIS filing, so we prepare the application. We give it to the foreign national, and they go straight to the consulate, US consulate or embassy in Australia. And on the spot, typically you would get an approval of that application. The job offered's got to be a specialty occupation, so it's very similar to the H1B. And then these are good for 2-year initial periods of stay, and they're renewable indefinitely, just like the TN is. And another, you know, positive about the E3 is that spouses can apply for work authorization. And then the H1B one for Chilean and Singaporean nationals, we did talk about this, 6,800 visas that are carved from the overall H1B cap. You can apply directly at the consulate, but an LCA is required. It has to be in a specialty occupation, just like the H1B, And this is what's important here. There's no dual intent, unlike the H-1B. Aaron, is there anything you'd like to add to this?
Just that, I mean, two things. One, just note that there's a lot of people that relatively easily become Canadian citizens. There's a lot of people from India and China that are Canadian citizens and kind of use that as their avenue to getting into the United States. Sounds like a lot of work, and it is. And then the other thing is, it's again unfortunate that it's only 5 nationalities of all the nationalities in the world. And while I think it's common to hire people from Canada and Mexico, Australia, Chile, and Singapore don't come up as often. And so again, it's great option if you happen to have an employee or a candidate who's a national of one of these countries, but we both know that in the grand scheme of things, the majority of people coming to the United States for professional work visa jobs are from India and China. And that's just the facts. That's the statistics. And so those are the individuals that aren't going to be able to benefit generally from these country-specific categories.
Thanks, Aaron. Okay, this is one of, I think I speak for both of us when I say this is one of our favorite O1 non-original categories. So the O1 is it's fun for us to work on. It's fun, for the foreign national. It's for persons of extraordinary ability. So really, this is a category that's open to people who have extraordinary ability in science, education, art, business, or athletics. And there's 3 different standards of eligibility. I'll talk about those in a moment. But really, when we talk about someone who's has extraordinary ability, we're really looking at people that are in the top percentage of their field. And that might be really difficult to think about right now. For instance, am I one of the top lawyers in top percentage of lawyers in the country? Or absolutely. Yes. Well, thank you, and that's
absolutely.
Very nice too. Probably not. Let's just say that, probably not. But let's narrow that. What we do, Aaron and I do, is we narrow that field. Okay, what about one of the top immigration attorneys? Again, probably not, but what about one of the top immigration attorneys who works within a certain niche field within the immigration, world? That's really how you could get this type of category to work in your favor. Another thing that's really important is that the Biden administration has really transformed the O1. So basically, the Biden administration wants more people, more students who are on F1. They don't get the H-1B to come and stay in the U.S. So what have they done? They've taken STEM fields, which is science. If you graduate with the science, technology, engineering, or mathematical background, you have a much better chance of actually obtaining this visa category. And again, I think Aaron and I have been really fortunate to have some of these cases where maybe during the Trump administration, this probably wouldn't have been approved, but now they're getting approved. I think that's really important. So just don't think just because you're just graduating, you can't get an O1. That's totally not the truth. Send us your resume. Let us look at it. Let us tell you what we think and even if we don't think that you have you have a strong case right now, we'll tell you what you could do to get a strong case and to get there. So again,
yeah, Jake, I just want to add, I think this is just such an important visa category right now because, it all comes back to the H-1B. And so the H-1B numbers, the fact that they're limiting it to 65,000 plus 20,000, so about 85,000 total, that's set by Congress. That can only be changed through an act of Congress. And I think we all know getting Congress to agree on something is awfully difficult these days. And so what the Biden administration did was they recognized the fact that, listen, unemployment rate is really low. We really, really, really need people, especially in STEM fields, to come work in the US. It's helping the economy. It's helping all these, technology and revolutionary companies we have in America. So we can't fix the H-1B problem, but let's at least make sure that those people that are the best of the best that didn't get an H-1B, maybe they can get an O1. And so this category, in my opinion, has completely transformed in the last year from something that was out of reach for a lot of people to something that is much more attainable, especially for people with STEM degrees and especially STEM advanced degrees, master's or PhD.
Perfect. Thanks, Darren. Yeah, and as an example, we just filed a case for someone who just has a bachelor's degree. They're on their STEM OPT. Typically, we were looking at people who had 10 years of experience, and they have all these accolades to their names. And this case was approved in 2 days. So again, there's a huge opportunity here. Don't think just because in the past this hasn't been available, it's still the same thing. Let us look at your resume. Let us let you know if it is obtainable. So again, the 3 different standards of eligibility: you have science, education, business, and athletics. Then you have motion picture or TV industry. So if you have someone coming here as an actor or as a producer, they might get an O1 to come here and work on a project. And then you have the arts, so fine arts, visual arts, performing arts. And the actual criteria is a little bit different for each of these, but we'll talk about the criteria here. So you're going to have to meet 3 of the below criteria. I'll kind of briefly go over these. So really the big ones are: do you have any nationally or internationally recognized awards or prizes? Are you a member in an association for which, really you're not paying for this association? Does someone say, we want you to join this organization and we're going to have, experts judge whether or not you can be admitted to the organization? Is there any published material about you and your work? Do you have original scientific, scholarly, business-related contributions? Are you the author of scholarly articles? Typically within the STEM fields, that's really going to be a big one, and one that we can just check off immediately. Are you getting paid a high salary for the services that you are going to be conducting? Have you ever judged the work of others? Have you participated on a panel within the field that we're saying that you're an expert in? And then, have you been employed in a critical or essential capacity for organizations who are established? Again, just 3 of these, only 3 of these. So it is possible. So that's it on the O. And now we're going to talk about the ETreaty traders and investors, which is a very interesting category. And it's something that, I don't know, Aaron, what do you think as an alternative to an H-1B? It could work, but you have to have, it's very, very unique in terms of you have to have a business that is the same nationality as you are if you're going to come utilize this.
Yeah, it's a really tricky one because there's 2 types of ease. The easier one to comprehend is you want to start a business. Well, this is the closest thing we have to an entrepreneur visa. We don't have an entrepreneur visa, which really makes no sense. But we have this E1 and E2 treaty trader and treaty investor visa, where if you want to start a business and you're making a investment of your own money and you're a nationality that qualifies, which we'll show you in a minute, is also problematic, you could get this E visa. But you could also get it as an employee, similar to like an H-1B. But what makes it tricky is you have to be of the same nationality as the ownership of the company. So like if it's an Italian owned business in the US, it's owned by an Italian national, and you want to work for them and you're Italian, that could potentially work. But if it's Italian owned and you're Portuguese, that's not going to work. And so it's not something that, like, if you're advising, students that are graduating how to find a job, you're not going to be able to say, okay, well, you're German, so here's a list of German companies. There's nothing like that available. So normally where we see the ease is either someone that is the principal investor themselves, or the other option would be maybe there's a business in Italy or in Germany and they want to open up something similar in the US, and they say, I got to bring my top people. These 3 people, they're all the same nationality. We're all German. I need them to come to America to help me run this business. That's kind of where we see the employee portion of the E visa come into play.
Thanks, Aaron. And yeah, I think a really good example of this, or just to kind of give you a roadmap, is someone who comes here and opens up a French bakery and the owner's French, and then they're hiring, people who are French, who know how to make the perfect croissant, right, and who might be managing the business. That's just kind of how we picture it. But again, you could be in any type of industry as long as it's owned by the majority of the person from that country. So again, this is available to business owners, managers, executives, or employees who are going to oversee or work in the enterprise. And then, like Aaron said, it's really a treaty of commerce or in navigation, bilateral investment treaties between the U.S. and the foreign states. So you'll see on the next slide that some of these are close to 60, 70 years old. Some of them are newer treaties. Again, majority ownership and control of the trading or investing company has to be held by the national of the treaty country, and foreign nationals seeking EE status must hold citizenship in that treaty country. So it's not okay to say, oh, I was once a citizen of France, and then when I was young, we left and we went to the UK, and I'm no longer a citizen of France, and I'm going to come work for a French business. You would still have to hold that citizenship. So there's two categories within the ETreaty trader investor visa itself. There's the treaty traders, so you're serving in a company in a managerial or essential skill capacity, and then there's the treaty investors, so the foreign nationals coming here to fill a key role within the company. And then spouses can apply for work authorization, which I know is important to a lot of people. Okay, so as Aaron said, we're going to look at this map, and all these countries in blue do have a agreement treaty with the United States, and you can see it's not a lot of countries. I mean, the majority of Europe, the majority of South America, Australia, just a couple of countries in Africa. What's really, really important here to note, and as Aaron said earlier, I don't know, the majority, 75% of people who come here to obtain work visas are Chinese and Indian nationals, and China and India are not eligible for E1 or E2 classification. To kind of piggyback off of that, Taiwanese foreign nationals are eligible for E1 and E2 classification, although Chinese foreign nationals are not. So if you were born in mainland China, you can't apply for this. If you were born in Taiwan, you can apply for this. And then some countries are eligible for either the E1 or the E2, or both. That's just kind of the way it goes. And then I think one of the interesting case studies there is Yugoslavia, before it broke down and became a bunch of different republics. The US's view is that Yugoslavia dissolved and the successors that made up Yugoslavia, so today Bosnia and Herzegovina, Croatia, Republic of Macedonia, Slovenia, Montenegro, Serbia. Now they retain that E1 and E2 status, so they can actually apply for this type of visa. All right, that's it with E. So let's talk about F1 student employment options. And a lot of people think, oh, F1, no, they're just coming here to study. But there is a work option as part of the F1 employment. So there's something called optional practical training, OPT, which is for pre or post-graduation training in a field related to the study that the foreign nationals here in. So it's a total of 12 months of OPT is allowed per degree program. And you can work part-time during the school year, full-time during vacations, and after graduation, you can work full-time. You're going to need USCIS employment authorization document and Form I-20 that's endorsed for OPT. And then typically the university is going to cover, the university's DSO office or ISSO office, they'll cover that Form I-20 and the OPT. The EAD employment authorization document, it's an open market, so it's not tied to a particular employer. So if you have if someone comes to you and they say, well, I have an EAD via OPT, can I work for you? Yeah, they don't have to have, as long as it's within the same field, they don't have to have an annotation that says, oh, they're going to work for X company. Yeah, it would work that they could come work for you. And then again, we talk about STEMs and we talk about how O1, we're trying to recruit and keep the top of the top people in the United States. So there's a 24-month OPT extension available for some people who have STEM. The only caveat there is that the employer is going to have to be in the E-Verify program. So if you've graduated in a science, technology, engineering, or math background, and it's on a list of acceptable fields or acceptable degree fields, you could have a total of 3 years post F1, post-graduation employment that before you even have to worry about getting an H-1B or an O1 or whatever other work visa category, which is, I think, fantastic. I think it allows for companies to to explore these, hiring foreign nationals that haven't had the opportunity to do so before. I think it gives foreign nationals the opportunity to work for different employers to see what they want to do. I think it's a really good program. And then there's something called curricular practical training, CPT, and it's basically when you're working during your degree program, and it can only be done if it's part of your educational program. Really, we don't advise on CPT. Sometimes it might not be the strongest option. It could hurt your chances of visas in the future. So just be careful whenever you see CPT as an option. Aaron, anything to add on that?
No, I think you have that covered.
Perfect. All right, J1 exchange visitors. This is one of Aaron's favorite categories as well. He's an expert on J1s. So J1 exchange visitors, it's open to trainees, interns, teachers, professors, research scholars, specialist students, au pairs, so people who are coming, nannies basically, and foreign medical graduates. Aaron and I work with a lot of foreign medical graduates. I think it's a very interesting area of law to work in. So basically, the J1 allows a foreign national to participate in approved exchange programs to gain experience, to study, to do research in their field. And they have to be sponsored by an exchange program recognized by the State Department. So like students on F1 visas, J1s are also tracked through what's called the CVIS system. And typically the DSO or the organization that's sponsoring this J1 or F1 visa would work through the CVIS system. Okay, so maybe you're wondering, can I change status from J1 to H1B, or can I change status from F1 to H1B? Like, yeah, you can do it from an F1 to an H1B, but it might be a little bit more complicated on a J1. And that's because some J1s have a 2-year foreign residence requirement. And I think really when you think about the J1, this was a visa category that was created to help people from other countries to come to the US to get training and to bring that training and knowledge back to their home country. So there are a couple of instances where someone would need to return home. So you'd have to return home for the 2 years after completion of the program before seeking another non-immigrant visa category or permanent residence if your field appears on the State Department skills list, because those skills are needed in the home country. If you've received any US or home government funding for the program, and then this is the one Aaron and I see often, is if you participate in a graduate medical training program in the US under the sponsorship of the Educational Commission for Foreign Medical Graduates. What Aaron and I work on a lot is helping foreign nationals seek a waiver of the 2-year residence requirement. Aaron, did you want to discuss some of the options there?
Waiver, I mean, given the time, I think we should leave some time for questions. If people have questions about waivers, we're happy to answer, but I think it's just important to know that some people that have the J1 just have this requirement to go home, but there are options to waive it and stay in the United States. And whether you can waive it is really a very individual analysis, but yeah, so it varies per person and per J1.
Thanks, Aaron. All right, and the last category we're going to talk about is the B1 business visitor. So this is a category that you should be really careful about. So foreign nationals entering to perform legitimate business activities. What are those activities that are allowed? Business meetings, conferences, joint development projects. The activities should benefit the foreign employer, not a US employer. And then the foreign national is going to have to remain on that foreign payroll. What can't you do? You can't come here and work your typical day-to-day job. That's not going to be an appropriate, B1 visa. The B1 is good for up to a year, depending on the duration of activities. 3 to 6 months is more typical, but really this is discretionary area where border officers can say, well, I'm only going to give you 1 month, or I'm going to give you 3 months, 6 months, or just outright reject your ability to come into the US on the B1 because they might not think that you are coming in for legitimate B1 purposes. There's no petition needed for USCIS. You just apply for the visa at a US consulate. And then for people from the below 39 countries, there's something called the Visa Waiver Program. Really, what that does is it allows people to enter for business and tourism for stays of up to 90 days without having to go to the consulate and obtain a visa. Restrictions on that program: any nationals who have been since March 2011 who have traveled to Iran, Iraq, Libya, North Korea, Somalia, Sudan, Syria, Yemen, or any country of concern designated by DHS, they cannot benefit from the visa waiver program. And then dual nationals from those countries as well cannot benefit. And then the foreign national is going to require ESTA advanced online approval to travel under the visa waiver program. So that's it. And I mean, Aaron and I are more than happy to open up the floor to questions. And thank you everyone for tuning in and spending the afternoon with us. Aaron, did you want me to just read through some of these questions?
Sure. Yeah, I see the last three in the chat box are all questions.
Okay, perfect. Is that the only questions?
Yeah. So the first one is Dean was asking if we could talk about EB5.
Okay.
Which, you know, we weren't planning to. I can give you kind of a quick overview. Today's focus was on temporary work visas. We're happy to come back and do another session on permanent visas, which are better known as green cards. And that's what EB5 is. So EB5 is a green card category for investors. And it's different from the E visas that we talked about because those are temporary investors getting a temporary visa. The EB5 is for someone that's making an investment in a business and providing employment to 10 US workers, and in exchange are going to receive permanent residence. And so that's what EB5 is. It's a minimum $800,000 investment, must employ 10 US workers. And so it's, to be honest, it's one of those green card categories that is usually our last option. We always try to find if there's easier, less expensive ways to get someone a green card first. If no other options are viable and the person has that money that they're willing to put at risk because they could lose it or they could get their money back but not make any money. If that's something that they're comfortable with and we've plotted out and found a good investment, then that's a route that we sometimes go for as well.
Thanks, Aaron. So how can CPT potentially hurt future employment options?
Hurt? I don't see how it could hurt. CPT really is extremely helpful. I mean, one small issue is that if a student does 12 months of full-time CPT, they lose their ability to get OPT, which is even more valuable. But otherwise, CPT, the best way to look at it is it's like internships while you're in school. And getting internships while you're in school, building up your resume, making connections with employers, that is only going to help you immensely after you graduate and you're trying to secure employment and sponsorship.
Thanks. And just to add to that, yeah, just ensure that the CPT is part of the program itself. It's not something that you're trying to do outside of the program. Stephanie Walsh, just a good question. I mean, I think this is a little bit more permanent residency related. So the PERM is part of the green card process. But I think it's a good question here to try to make the PERM stronger so that, you know, maybe you don't find qualified candidates and you can continue hiring the foreign national. There's a couple of things you could do here. And I think it's one of the big issues we see is that someone who's been with the company, that's their only experience. They were hired straight from their F1 to H1B. They haven't done anything else. They don't have any other experience. How are you going to say they have X amount of experience? Because you can't use the experience that they've gained with the company in a similar position. So I see, Stephanie, that you've asked, it was experience outside of the sponsoring company. The thing is that they can have experience with the sponsoring company as long as the role that they're being sponsored for is at least 51% dissimilar to the role that they're currently in. And there's ways that we can illustrate that and show that. And typically what you would do for this type of application is someone's been maybe promoted to a role that's 51% dissimilar, or you would sponsor someone for a future role, maybe not the role they're in now, but the role they might be in when they do get the green card. Quick question I had was, I'm a STEM student. Can I do business and do my full-time job on OPT? I'm not really sure what that means.
Yeah, I'd say maybe he means he wants to start his own business and work for a company at the same time, which On OPT is perfectly fine as long as both jobs relate to your major. On STEM OPT, having your own business is unfortunately not an option. So you could work for that company if it relates to your degree or your major. But unfortunately for the STEM OPT extension, you can't be working for your own business.
Thanks, Aaron. Okay, it's possible to register for a visa card for students, employee.
So maybe she's asking how a student can work and can be an employee, which I think are the options you mentioned before. Pretty much CPT and OPT would be the ways for somebody on an F1 visa to be able to work. In addition, all F1 students are able to work part-time on campus while school is in session. So that's why you often see that they take graduate research assistant and positions like that they can get paid for because it's on campus employment.
Perfect. And then Cesar, you're a civil engineer, class of 87. How can you get a work visa? The best way is to find someone to sponsor you for a work visa. If you can find an employer that's willing to sponsor you. I mean, Aaron, what about any other ways to come here to set up a business possibly?
Yeah, all the options that we discussed, but generally, you know, option one is going to be find an employer to sponsor you and win the H-1B lottery.
And then it looks like that's it for questions. Any other questions?
Looks like Jimmy just sent one.
Yeah, Jimmy said, can I work part-time CPT remote for a company in New Orleans and work as a TA on campus? Yeah, you can. You need to talk to your F1 advisor because working remotely is one of those gray areas right now, again, because the laws were written before that was really possible. I am of the opinion that remote work for CPT is acceptable as long as the other requirements are met. But it's your F1 advisor at the school that actually has the final say to determine if that is permissible or not. So regardless of what I say or Jake says, you definitely want to run it by your F1 advisor and make sure that it's okay with them.
I wanted to, thank you both for today. I think you covered so much information and I appreciate the conversation and discussion. I also wanted to circle back to something that the three of us were talking about before we started in terms of, you know, how can everyone on here and people watching the recording, if they have questions, what are some other ways that they can connect with you outside of the questions pertaining to today's presentation?
So I just put in the chat our email addresses. So please feel free. If you have questions, you want us to look at your resumes to see whether or not you have a good O1 or whatever, please feel free to reach out to us. Aaron and I do this all the time. We're happy to help, happy to provide kind of our you know, high sense level overview of what your options might be.
Perfect.
I mean, even as students, employers, anyone in any field that pertains to, you know, any immigration, we're happy to help.
Great. And if other law students, law grads wanted to just network outside of temporary visa, you know, kind of, can you just generally overview, like, you know, who do you want to network with? Who do you want to come to you?
I mean, Aaron and I are always looking, you know, Fragment's always looking to hire, you know, and we're looking for a great candidate. So if you're interested in immigration field, you want to ask us questions, you know, maybe a summer associate position, something like that, let us know. You know, we'd be happy to provide your resume to the relevant source who could then consider you for the job. I know Tulane has a really good program with Fragment. We have a lot of Tulane graduates who are attorneys here at the firm, and we do send someone to the law school every year to do recruitment. And we do have a lot of undergrads that graduate and are here in caseworker, paralegal, different types of positions within the firm.
Wonderful. Well, again, thank you both. Thank you for your time, and everyone on here, you have their information if you think of those questions as soon as I hit end, which I know always happens. You want to close us out with any final thoughts?
I think that's it. Just like, don't, feel free to reach out. We're here to help. We want to help people. And then I guess the last thing I'll say is roll wave and thank you.
All right. Thank you, everyone. Have a
Thanks,
good day.
everyone.